Hello and happy Friday to everyone. My name is Christina Jimenez with Jimenez Law Firm. I guess let's go, Julie, ladies first.
Hi, I'm Julie. I'm also an attorney at the Jimenez Law Firm.
Floyd.
And I'm Josh. I am also at the Jimenez Law Firm.
And James.
And I'm James. I also am at the Jimenez Law Firm.
And y'all are attorneys, right? Yeah.
Yeah.
Floyd.
Depends who's asking.
Okay, excellent. So every Friday at noon, we come together and we go through some complex fact patterns. Sometimes they're complex, sometimes they're pretty simple. Sometimes we don't know the answers to the questions. And so we kind of go
really complex.
Right. We kind of we're reading these questions and we're hearing the facts as we go. And so we always tell people at the beginning, middle, and end of these sessions that please do not accept this as legal advice, okay? What we like to do is we like to kind of sit down and talk through these legal issues, but we don't know your legal issue. And so it is so important that if you are in a custody dispute or you're going through a divorce, or if you're a grandparent and you want to have rights to your grandbabies, whatever it is that you have going on, please find an attorney that you feel comfortable with, preferably in the area where that case is going to be heard. Sit down, talk to them, and tell them your facts and the issues that you're dealing with. Because as you will see, as we're talking through these fact patterns, it'll change, right? Our opinions on things will change based on one little nuance that comes up. So with that being said, don't accept it as legal advice. We do ask that everybody follow us on Facebook, Twitter, Instagram, TikTok, any social media platform you can think of. We are on it. And I want to make sure that we're spreading the wealth, spreading the information that we have, because I do hope, and that's kind of the purpose of all of this and why we started it, is that it at least gives you a little bit of insight as to what the courts are thinking, what lawyers are going to be thinking, and that you can use these little tidbits of information to help you throughout your case and maybe make you a better parent and maybe avoid, costly litigation. So with that being said, who wants to roll with question one?
I just want to say, holy cow, if we make that introduction any longer, we're going to have to extend the show. That went on forever.
It was literally like a minute.
Oh, I was like, gosh, she's still talking? Jeez.
No, I have to share all that information. No, not relevant, not needed. Too much.
Some of it, but we need to figure out.
If it wasn't a thorough disclaimer, it wouldn't work, Floyd.
Thank you. The people must know. So, Floyd, why don't you read the first question? Since you're tired of hearing me speak, apparently.
By all means, I don't want you to read it. So I've been divorced since 2019. I did not ask for child support. Can I go back and ask for it now? I was advised by my attorney not to file for child support at the time because I had too much to lose. My financial situation has drastically changed and I could use child support for child care. Who's going to answer?
Did you finish the question?
Yeah, that was the period when I stopped.
Well, I was focused on getting my Facebook Live set up and I wasn't actually listening to the question. Am I supposed to answer this question?
Sure, go ahead.
Okay. So can they go back and ask for it now if they were divorced in 2019? So yeah, you can modify it, right? She can't go back and get retro support to 2019. I don't know if that's what she's asking for. So if she were to file a case right now and request a modification of child support, yes, she can get a modification of child support potentially. Okay, so it is kind of a little bit of a risk if ever you agree to support below the guidelines or any sort of a deviation from the guidelines. So it can be above or it can be below, okay? Because the way that it works is in the state of Texas, they have child support guidelines based on somebody's income. Okay. And people can agree to deviate from that. They can say, I want it to be higher. I want it to be lower. And if you agree to that, then what happens is when you try to go back to court to change it, you have a higher burden of proving a material and substantial change in circumstances, right? And so what a lot of judges are going to want to see is what is the significant change that would now warrant him paying child support. She says that her financial situation has drastically changed. So maybe that would be something the court would consider. Maybe, Floyd, maybe.
I'm just saying that drastically versus material and substantial change, I don't know that she can meet the burden.
Which is why I said maybe.
She said drastically. Had she said that there's been a material and substantial change in her financial situation, she would have been able to meet the burden for sure.
Been able to use the actual language. That's funny.
And perhaps if she knew what the burden was, then she wouldn't be asking the question. So
and if you're watching this next time, she'll ask it correctly.
Exactly. And so the other thing that we don't know, and again, going back to why you guys can't take this as legal advice, we don't know what his position is, right? We don't know if, he was making $100,000 in 2019 and now he's making $50,000. We don't know what their possession schedule is like. Are they following the order or have they switched that up? So there's a lot of different things that the court can consider. And those are the kind of things that I would want to know before I make a determination as to whether we should file or not. I mean, a lot of times, like let's say drastically, I don't know what's drastically like.
Well, yeah, I was going to ask, could you all give some examples of what you've seen to be a mysterious? That's good.
Material. That's a different burden.
That's right. A mix of material and substantial. You got mysterious, right? So substantial change. Good example would be like maybe a death in the family.
No. I mean, they're looking at
serious illnesses.
What?
Serious illnesses, disabilities.
Yeah. Mm-hmm. But like, I don't know, Floyd, if she's making $20,000 less a year.
So I think that she would have to show how that has materially substantially impacted her living environment, right? Or impacted her life, right? If there hasn't been a material substantial change in her life, I don't know that, because it's material substantial change in the circumstances in this case, not in the income, is the way I read it.
So, but the other thing is, and this is why I always say, hire an attorney that practices in your jurisdiction, wherever your case is, because it depends on the judge, right? A lot of judges are not okay with people not paying child support at all. A lot of judges are not okay with a deviation from the child support guidelines that would drop it below what they're supposed to be paying. So not my case, but I was talking to another attorney and he had told me that they had set child support above guidelines. And because the dad was making like $300,000 a year or something crazy. And the dad, about a year later, after the order had been rendered, files a motion to modify. And in the motion, he says, well, I'm not making $300,000 anymore. I'm only making $275,000. And also my kids don't want to come and see me because mom is alienating them. And so I don't want to pay I think it was like $4,000 or $5,000 that he agreed to. I only want to pay what the max was, which was like $2,200 or something like that. And in that particular court and in that case, they dropped it down to the $2,200 to the guidelines. And so I think that there's all sorts of different factors that the courts can consider. And obviously there was no finding of facts, and we don't know if it was the visitation that got the judge. We don't know if it was the $25,000 pay decrease that got the judge. I don't know, but that's what he ended up doing. And so I would want to know more before we made a determination. And a lot of times we'll say we can try. I mean, the only thing that could happen is judge says no, right? You'll be out attorney's fees, which that sucks. They may try to hit you with attorney's fees if it's a frivolous suit, but we would never file if we thought it would be to that level. So,
Well, the other thing is, I'm going to go with her attorney was smart, and there was something going on, and told her not to pursue child support, maybe because she would lose custody, right? And so, what's going on with that, right? Where do we stand on that? Because we don't want to place you at risk of losing something that's more important to you to get some money. So, I think we'd have to dive into that situation a little bit and see where we stand on that.
well, and she says she needs the child support for childcare. So I would want to know. And so I guess let's kind of go back and let's look at material and substantial change in circumstances. So typically what you're supposed to do when you're proving up a material and substantial change in circumstance is you're supposed to look at what was going on at the time of the order, of the previous order. So back in 2019. So how much money was he making? How much money was she making? Was maybe grandma taking care of the kiddo for free? You know, what was health insurance like? Like what's the visitation like? All of that stuff in 2019. And then you have to draw a comparison to what we're dealing with now, right? And so if now maybe grandma passed and we need to pay $1,500 a month for childcare, maybe, you know, she was in an accident, she can't work, like those kind of things. That's what the court's going to want to know when determining, yeah, I'm going to go ahead and give it to her. So yeah. I would like it. I would like to see more. Okay, Julie, you want to read the next one?
Sure. What can I do if my child does not live with her mother and she is still receiving child support and food stamps? My child's mother does not have my daughter. She is living with a relative, but she is receiving child support and food stamps.
So is the child the she or is the mother the she?
Mother.
Mother.
Floyd, go.
Oh, I didn't know I was
You're
up.
tired of hearing me freaking talk.
I am for sure. I didn't know if James or Julie wanted this, but I'll take it. All right. What can you do? Fight for custody, maybe. I think it depends. The short, straight answer is if she has the right to designate the primary residence, she can determine where the child lives. And if she determines the child should live with grandmother, then that's her determination. And you still have to pay child support. So there's nothing you can do about that. However, this is a good opportunity for you to evaluate the living conditions of everybody and potentially go in and fight for primary, where mom will be paying you child support. Courts, generally speaking, would rather the child live with a parent. And so if you can establish that mom is either incapable or unwilling to care for the child, which is why the child is living with a relative, and you are not only capable or willing to care for the child, there's a good possibility that the child will come live with you. We'd have to go back and look at the prior order, see what it says, when it was rendered, that kind of stuff, because if it's within a year, our burden's really high. Do you want me to go into all of that?
I don't know. If you were just like a lay person just listening to this and not a lawyer that had been practicing law for 10 years, would you maybe want to know about that?
Well, I don't know if it's responsive to his question.
What do you mean?
What's his burden if it's within a year?
Yes, you don't know. But yes, Floyd, this happened like 6 months ago, is what I read in this question when I read it.
Oh, you must have the extended version. I didn't get the.
Yeah.
Okay. Yeah. So if it's since it's within a year, right, you're going to have to prove that basically the child's in danger where the child's living, right? There's significant impairment to the child, that kind of thing. So it's a high burden. So if it had been outside of a year, if the fact pattern were different, right? If it had been outside of a year, your burden would only be best interest. So at that point, you would just be going and saying, look, it's better for a child to be with a parent than a grandparent or a relative. But since it's within 6 months, right, and we're within this year, you're going to have to show that the child's in danger over there at this relative's house.
So that's something that I think a lot of people don't get. And it's a question that I get a lot in consultations is, well, the kiddos are not living with mom, right? But in your orders, like the standard language, it says the right to designate the primary residence of the child. So it's just a right. It doesn't mean that the kiddos have to live with her. She has the right to say, kiddo's going to go live with grandma because that's what I believe is best for whatever reason. So she can do it. And you still have to pay child support to her if she has that right. Yeah.
I concur with that statement.
What do you think about the food stamps then, Mr. Floyd?
I think it depends. If she probably said the child's living with her, which would be an issue, right? Unless maybe it's a temporary placement and the child's not residing with a relative, but rather staying with the relative on a temporary basis while mom gets her crap together, right? So again, I would want to know more. I've never really had a lot of success with that argument, I guess, because I've never actually, when I found out I could prove that they were doing food stamp fraud, it never actually went to trial for some reason. So I don't know that I've ever heard a court address that issue, right? When I'm like, here, ABC, I can establish food stamp fraud. They're like, okay, what do you want?
Right.
I don't know why they do that, but so yeah, I don't think the judge would like it very much, but I think that if it's for a short period of time and mom has a good reason for the child staying at the relative and the mother is taking this money, food stamps and child support and caring for the child, I don't think the court would really care that much.
So, and I don't know, I haven't actually like dug into it, but I thought if you're receiving government benefits on behalf of the kiddo has to reside with you. And if there's any change in that circumstance, you have like an obligation to report it so that they can then, you know, change your benefits. Julie, James, do you guys know about
So I will say that I have seen the fraud issue with food stamps and stuff come up in a trial. The judge does not like it, and it goes pretty poorly.
So I guess what it comes down to for me is, right, what does reside with mean, right? I mean, if mom has to go to Alaska for work for a month and the child's staying with the relative, does she have to then change the food stamp stuff?
No. Yeah, no, I think you're on task with if it's a temporary placement for medical reasons or for career reasons or whatever. I don't know. And we would obviously, if we had a case like this, want to look up the criminal provision or the penal code provision with regard to that type of fraud. But I mean, this question says she is living with a relative. So I'm going to go ahead and go out on a limb and say that it is a permanent type of situation that's been going on for 6 months, specifically in the extended version of the question. And so I believe that mom would probably have some issues with committing fraud. And so like there's a couple of things that could happen is there could be some potential criminal charges filed against her. And also in the context of a potential modification, right? And so I guess let me ask you that, Floyd, if you repped dad, you said that you would potentially file for primary custody, depending on the living situation. What else would you maybe file? Maybe just fight for custody and then during negotiating, get a reduction in support, or maybe have the money go to the grandma if he really wants to continue to support the kiddo.
Oh, well, I wasn't even thinking about me losing because that doesn't happen. So you're talking about if I went and I lost?
Yes.
Oh, okay. I don't really have any experience with this. You can tell us, what is it like when you, just kidding.
Well, I always like to have contingencies, Floyd, you know, just in case. So, I mean, that's the other thing that he could maybe try to do or negotiate is like, I want these payments to be directed to grandma, or I want a reduction in my support. But I think when you put mom on the stand, if I'm mom's attorney, I am not letting her answer any questions with regard to food stamps. But I agree with Julie, like That's not gonna be good for her at all.
Well, another thing you have to be careful of with this assigning child support to grandma or whoever it is, right, is standing for them in the future, right? And with the child residing there, how long they've been there, do we want to try to stop them from being able to get standing? So you have to kind of keep an eye on that. What you really need to do is hire an attorney that knows about all these issues. There may be a bunch of people who were talking about it and kind of knew how to spot all this stuff. That's
Well, but that you could tell them like specifically what's gone on in your particular situation and all the nuances associated with your situation. And then they could tell you how to do it, right? Yeah. So I think that until you modify, the answer to the question is until you modify, yes, she gets your child support and she gets the food stamps, and there's nothing that anyone can do about it.
I concur.
Okay, but if you modify, you might win custody. So hit us
Or you
up.
might give grandma standing if you hire the wrong attorney.
Jerk. Okay, next question. I will read it. What can I do? Have been with my boyfriend for 10 years, just to find out a week ago he has been married for 4 years. Exclamation point, exclamation point, exclamation point. He married his wife to help her get her citizenship. We did not know anything about one another. I am 4 months pregnant, and when I told him about the pregnancy, he asked me to keep the kid. I have him on tape agreeing that he would put me up in a place to stay and pay the rent because that is what his intention was before he got caught. What do I do?
Okay, I'll take this one. It's an interesting situation because you don't have your baby yet. You're 4 months pregnant and y'all aren't married because he still is married. So there's a lot you can do. I mean, you could stop seeing him, move out. I mean, legal remedies. I mean, I probably hold on to those text messages. You may be able to use them later on as ammunition. But as of right now, I mean, maybe you guys can help me out, but I don't see a whole lot of legal remedy in your situation. Maybe intentional infliction of emotional distress. That's always a good one.
No, it's not.
EDO.
So, and I always get it confused, Floyd, the meretricious and the punitive spouse.
Yes. So I think the meretricious is the spouse that was unaware. The punitive spouse is the spouse that's a jerk.
Right. So maybe, and again, I'm just going to go out on a limb and say,
Using the extended version of the question.
right, making up the facts as I go. So, if in fact he was representing to others that the girlfriend, the one that's now pregnant, was his wife, like they were holding out, they had
Took my thought.
don't try to claim my stuff.
She does say boyfriend. That's all I'm gonna say. She does say boyfriend in the question.
This would be privileged information.
Okay. All right.
So I would want to know if they were holding out as husband and wife. And so to establish common law marriage, you have to have 3 things. You have to have cohabitation, you have to have an agreement to be married, and then you have to have what we call holding out. Okay, cohabitation means you live together. There is not a time frame. Drives me absolutely freaking nuts when people say, oh, well, we lived together for the requisite 6 months. Not a thing. You just have to live together, period. And you have to have an agreement to be married. And so that's always kind of a tricky one because people normally, when you become a common law spouse, it's not like you sit down and you have a formal conversation of, okay, are we going to agree to be married? Right? It kind of just manifests, right? So you get to use the evidence that you use when you're holding out to third parties that your husband and wife. And basically all that means is that you tell somebody like, hey, this is my wife. Hey, this is my husband. Here's our tax returns. Here is the insurance that we filed together. Here is, I used a quinceañera invitation one time where they sent it to Mr. and Mrs. Jones, and that was enough for the court to say, well, other third parties believe that you guys are married, so I'm going to find common law marriage. Okay. And so in this particular case, if there was any evidence to establish that she was in fact a, what we call a meretricious spouse. Are you checking me on that, Floyd? Is that right? You didn't check me. You just checked me. Well, that was rude. So if she's a meretricious spouse, I think that's what it's called. That she did not know that he was married to this other third party, and she believed herself to, in fact, be his current spouse, then she would have all the rights and benefits that would otherwise be afforded to a real wife. So that means spousal support, that means potentially assets, it means all sorts of things. But there's some qualifications, right, Floyd? Like as soon as she finds out, she has to bounce, like she can't live with him anymore, and they can't have sex. Like there's stuff that happens with all of that. But maybe that would be something that we could look into.
So I was gonna, yeah, I guess it wouldn't help her to go the other way. I was gonna say that maybe that second marriage is void or voidable if there's a prior marriage, right? So if you establish common law marriage, this after the second year they were together, because he got married while they were together, right? They've been together 10 years. He's been married for 4.
Mm-hmm.
Oh, shoot. I missed that.
Right. And they could have been off and on. You see what I'm saying?
Yes.
Just saying.
Floyd has, that's an excellent point, Floyd. To go complete your thought, because I know what you're saying, but I don't know that everybody else knows what you're saying.
Yeah. So if you can hold that other, if you can establish the marriage, that there was in fact a marriage, and hold the other marriage, I always forget whether it's void or voidable, I get confused. They would basically void out the second marriage, which means that they are currently married. If they're currently married for a period of
Floyd,
10
you are not explaining this well at all. Like at all.
Why?
Because you're like, as you can establish the first marriage and the second marriage, and like what marriage are you talking
All
about?
right. All right. I'll break it down. Okay. So common law marriage, like Miss Jimenez was explaining before, right? If you can establish common law marriage, once all of the elements have been met, by the way, I forgot to mention, I think if you hold out as married, then you are presumed to have an agreement. Is that right? Yes. Okay. Anyway, so if you can establish all 3 elements of common law marriage, then you are married. You can't just get unmarried, right? Anytime you're married and
So pump the brakes though, real quick, just so it's, which means because the girlfriend, right? The lady that's currently pregnant, that's claiming to be the girlfriend, and we'll talk about that later.
the wife, when we
The
get
wife, the real wife,
Right.
that's been with him for 10 years. If they establish that after being together for 1 year, then the citizenship wife, that marriage is void. The one that he's only been married to for 4 years.
right.
That's what you were trying to say, because you weren't making it clear.
I was in the middle of breaking it down. So
Okay, break it down.
once you are married, once you meet the 3 elements of common law marriage, you can't, there's no common law divorce, right? So you are married. If that was established in year 1, like Ms. Jimenez says when she interrupted me, that was established in year 1, then you're still married. Even if you separated for 5 years, you're still married, right? And so that second marriage, like Ms. Jimenez was saying in the middle of my explanation, would then be void or voidable. And so at this point, as we sit here today, you are married. And if we can establish 10 years of that, eligible for post-divorce spousal support as well.
I like where your head's at, Mr. Floyd. I like it a lot. So
I think I got a term of art, void ab initio, because the marriage was contracted during an already existing marriage.
the
I want
void
to-
at the start, Latin.
There it is. Boom.
I honestly don't know that that's what it means, but it makes sense. So, so yeah, the second marriage would be done, and she could maybe try to get some some spousal support while she's pregnant with this jackass's baby, and then child support, obviously, when the baby's born.
Right. Now, if you're listening to this answer, no, we read in some facts there. So please
As
consult.
we do with all questions.
So in your 20-minute opening, you should say, I tend to make up a lot of facts.
Okay, I'll do that next time, Floyd. Okay. Alrighty. So let's go to the next question. Let's do question number 9. Floyd, you want to read that?
I'd love to. if you guys
Thank you.
don't.
I greatly appreciate that.
Okay. What makes a protective order valid? So my ex filed a protective order against me and later filed violations. My question is, what if I was never served the documents? They claim they served me leading. Oh God. They claimed they served me leading to me missing a court hearing I had no idea was even taking place, resulting in the protective order being granted by default. When all this was going on, I was selling my house and I have proof. My realtor can be a witness and a friend can testify I was staying with him while my house was being sold, right? Question mark. Can I argue this in the violation cases? Okay, so she's talking about being served with the notice of hearing. I was thinking served with the protective order, and I got really confused there. All right, go, whoever's going to do this.
So, yeah, you have to have service on a protective order. So with this question, when you're doing a protective order, there is an ex parte protective order that is normally signed with the court that grants relief up until the time of a hearing. But you have to get notice served to attend that hearing. If you can prove you didn't, then you can file with the court and fight it. Default has already been granted.
Did y'all miss part of her response because she broke up for me?
Yeah.
Okay.
Yeah, my internet's really bad today. Sorry.
It's okay. Repeat, por favor.
Oh, you want me to try? Okay, on the internet again? All right.
Again, please rewind.
So I'm not sure which part, but with the protective order, there is an ex parte protective order that is normally signed by the court upon filing a petition that will hold for 20 days until a hearing can be held. However, there has to be notice served upon that party that the protective order is being sought against. If there is not service, then obviously the hearing can't go forward. It sounds like in this case, they were able to prove up some sort of service to the judge. So if you believe that's not valid, then you can file with the court to try to get that voided out with a new trial. It is a very hard and high burden, though, once a default's granted.
If you were properly served, right?
If you were
And
properly
so-
served.
So let's talk about service. So basically, like anytime a lawsuit is filed, you have to be given a copy of what was filed against you, right? And typically we do what we call personal service, which is basically a process server finds you and they physically hand deliver that paper to you, right? And then they file a document with the court, what we call a return of service, saying, hey, on this day, I gave this paper to John Smith, and then the time clock starts ticking, right? You have until the Monday following 20 days of service at 10 a.m. to file a response to say, hey, judge, here's my answer. Don't let them go to court without me, okay? Without me being there, without them telling me about it, right? You file that answer. From that point forward, they have to send you a notice of hearing before they go to court and they try to get anything granted against you, okay? So like Julie said, if you got that document and there's a return of service on file, then you're pretty much toast. Like there's nothing we're going to be able to really do because you kind of screwed up and you missed the deadline. I say that I've had some new trials granted before, kind of in this situation where there'd been a death in the family and her mind was just all over the place, and they were moving and she lost the paperwork. So we've had some success, but again, it depends on your judge. And the big things with motions for new trials is you have to file the motion within 30 days. And you have to have a hearing within 75 days. And then the order has to be signed within 125 days.
Yeah, we used to think it was one thing and then it got extended again.
Yeah, so something like that. So the
35 days.
rules on motions for new trial, like what's in the motion, when it has to be filed, like super, super technical. And every time we have one of these, we're always opening up all of our books and we're making sure like we got this right, because we don't want to screw it up. But if you were personally served and you missed it, we would want to, again, sit down and talk to you and figure out, is there maybe a chance that we can get this thing set aside? The other thing is if they couldn't find you, maybe they did a alternate service or service by publication, but if she knew where you were and she filed that, then we could probably get that set aside, because that would be a violation of your constitutional rights.
Yeah, I'm thinking it was a alternate service thing. Like they served by posting or something, because she wants to establish that she wasn't living at that residence. If she was personally served, then that wouldn't benefit her.
She wants to establish she wasn't living at the residence. What do you mean?
So she's saying that I can prove I was selling my home at that time, like I wasn't living there.
So
And
my
if-
realtor, go ahead.
If she was personally served, it wouldn't matter where she was living. Right.
I see what you're saying. So that they posted it on the door. And so that's why she didn't see it.
Yeah, that's what I'm thinking.
Yeah, I would want to know, did this other person know where she worked? Did she know like where family members were? Did she know that the house was for sale? What can you use to establish? And all of those guys are super, super hyper technical when it comes to facts and establishing what the other party knew when it comes to a violation of your right to notice of a lawsuit.
Well, so you're talking about service for the hearing, right? She can't be in violation if she didn't get service of the actual protective order that was granted.
Well,
Right.
yeah, but she knows about it clearly because she's asking the question.
Yeah, so he filed for violations, right? And so she's wanting to try to argue against the violations.
Are you reading the extended version?
No, which part of that? I'll point you.
Oh, and later filed violations. Okay, I got you.
Yeah, so maybe she just got served with I guess it would be an enforcement.
That or some criminal charges.
Right.
Yikes.
But if she didn't actually get service of the protective order, then she's not bound by it. So who gives a crap about the notice of the hearing, right? It sucks to be defaulted on protective order when it was issued. But for purposes of arguing the violation, you establish you didn't get actual notice of the protective order. You can't be held responsible for the violations.
If it's a contempt proceeding, and then if it's a criminal offense, because a violation of a protective order is also a criminal offense, and you can be criminally charged for violating a protective order. And so you would argue that to the DA or to the police or whomever, depending on the phase of the case.
Yep.
That sucks, dude. And so, here's the other thing as attorneys, just to save people, a bunch of strife and criminal charges and craziness. The judges don't always check for returns of service. right? Like some of them do, and a lot of them, you know, they'll take the time to look at the file. Let me make sure that they're served, but some of them don't. Some of them are like, okay, did you handle your business? Like, did you get them served? Yes, no, whatever. And they presume that as an attorney, if you're there and you're asking to proceed with the default, that you served them and the returns on file for the requisite time and all that good stuff. And so I have had it happen where they go in and they default, they didn't have service, they get that order, and then we have, you know, bill of reviews, motions for new trials, all sorts of craziness. And it's just, as lawyers, we should probably be a little bit better than that and make sure that when we're putting these people through this stuff, that it's all good. So.
And when you're talking about alternate service and service by publication, the requirements for those are really strict, and the affidavits got to be attached and all that. And so if you can attack that, you're right. I mean, there's some things to look at, you know, all hope is not gone. Hire somebody that, you know, can intelligently talk about all these issues.
Like yourself, Mr. Floyd?
That's a good idea. You do that. That's a good idea.
Okay, excellent. Awesome. So we do have a question on Facebook. And so I do believe that we can answer that question. So it is from Anna. She says, I am currently fighting for full custody against my kid's father, who hasn't been present in my kids' lives. My 6-year-old barely met him. I am married and looking to move out of state. He owes me $32,000 in back child support, and he only started trying to see them a month after I served him with papers to take away his rights. What kind of outcome can I see happening, especially if my kids don't want anything to do with him? Who wants to take this? So I'm going to start this. I'm going to start this because this is why it is so very important that you are hiring strategic thinkers as attorneys. Okay. So a lot of attorneys, you come in, you say, hey, I want a termination of parental rights. And they say, cool, let me draft a petition. Let me get this filed. Let's get him served. And then we'll see where this thing goes from that point forward. When we get these types of cases, I'm going to just kind of brag on us for a little bit. We will kind of talk through the personality, like what's Dad's personality, like what's his MO? Is he one of those that's going to be indignant and want to fight you when he's served with this? Do you think he's probably going to agree? Does he care about paying his child support? Has he violated anything in this order that we could potentially use, to hang over his head, right? And so when you're consulting with attorneys, make sure that y'all are having those types of conversations because they're very important. If his personality was probably like, yeah, I don't want anything to do with the kids, I haven't seen them, he tells you I'm going to give up my rights, then great. The way that this attorney did it is the correct way to do it, right? But like it sounds like now, he's pissed off and his ego's maybe bruised. And so now he's going to show you that he's going to be a good dad. Now you have a problem. And so a lot of times when I have those conversations, I don't even file for the termination. What I file for is an enforcement because a dad, you don't like this? You don't like me saying this?
I don't like it being admitted to.
It's like, ouch.
Well, no, because it's Dad's choice at that point, right? I mean, I don't make him do anything. I file an enforcement. You haven't paid your child support. You get to be held in contempt of court. And I would say 9 times out of 10, I get the call from their attorney saying, hey, he doesn't want to go to jail. He has another family. He has a job. What would your lady think about a termination? Let me talk to her. And then we go from there. In this particular case, an enforcement is in place. If he doesn't care, then if he didn't care about going to jail, then he just gets to go to jail and he gets to keep his rights. So, yeah, I mean, and that's what I would have probably done in this particular case if he hadn't seen the kids. filed two things. I would have filed an enforcement. I would have filed a motion to modify, requesting restricted access. Because if, again, going to the psychology of this stuff, if I believe that once dad is served with something, that his immediate reaction is going to be, I'm going to go and start seeing these kids because I want to hurt mom because she's trying to hurt me, then I'm going to file a TRO, extraordinary relief. I'm going to request that he be denied access because he hasn't seen the kids in 6 years. And I'm worried that he's going to try to exercise his full summer visitation. And my kids don't know who this man is, right? So I would get both of those things in place first. And that way we know that the kiddos are protected. And then if they were to bring the termination to us, then that would be in place. So if all of that is in effect, then if he doesn't want to waive, he doesn't have to waive. That's his decision. Involuntary terminations. Okay, so there's two types of terminations. There's going to be a voluntary termination and an involuntary termination. Voluntary means he shows up, he has two witnesses in the presence of a notary, and he says, I have all these rights, I'm waiving them, I'm done. Right? A involuntary termination is when you petition the court and you say, Judge, look at all this bad stuff that this person has done. And there's like 17 different ways to get an involuntary termination. Typically, they're going to revolve around putting the kiddos in some sort of danger, being in jail for a couple of years. There's not paying support for a certain amount of time before you file. I don't like that. I don't think terminations on an involuntary ground based on non-payment of support, never had any success with it, and don't think that judges would be inclined to grant that. But if you can't meet one of those 17 elements on an involuntary termination, he's going to have his rights.
Yeah, involuntary terminations are very, very difficult. A lot of times what I see attorneys file when there hasn't been support like this is on two grounds, right? Failing to provide support in compliance with the court order for a year, or leaving the child in the care with another without providing support, right?
And expressing or not expressing an intent to return, something like that. Like basically abandoning the kids. Yeah. The leaving the child with another without providing care, the case law doesn't support that position. Basically, it says that if he left the child with you and you're taking care of it, then the child's fine, right? The 1 year is difficult because you have to go back and prove each month that he had the ability to pay, right? Which can also be burdensome and difficult. And then if you get past that, you still have to have the court define this in the best interest, which is very, very, very difficult in Texas to have someone's rights terminated. As far as, she's kind of want to know what can I expect as far as an outcome goes. It looks like maybe the termination was filed so that she can move out of state, right? And so I think that it depends, right? On so real quick, she just said he moved for a year, 5 hours away. Does that help? Is he back in the geographic area?
While she's responding to that. So assuming he's back in the geographic area, because she's giving us the extended version as we talk. But I think he's back in the geographic area because she said he had moved for a year.
Okay.
So if he's back in the geographic area, most of the time it's difficult for you to be able to move out of state. However, you have some facts working in your favor, right? He doesn't have a relationship with the kid, or hasn't had a relationship, hasn't shown a desire to have that relationship, which is something the courts do look at when determining whether to restrict it, right? To restrict the geographical, or to have a geographical restriction for the child. But if he's showing an interest now in wanting to have that relationship, they may let him. And then it depends on, I guess, why you are wanting to move, right? In this case, just off the top, I'm thinking if you were going to get a better paying job so that you can.
She's filed because she's moving on with her life, and the husband wants to adopt the kids, and the kids want to be adopted. And the husband's job is out of state.
Okay, so this is the type of case where we just, win the battle or lose the battle to win the war, right? And or win it one battle at a time, depending on how it goes. It's going to be very, very difficult for you to get that end result right now if he's fighting for custody. So take it one step at a time and just make his life miserable until he gives up.
Or make improvement.
Can we edit that some way?
Can we try it a different way? Let's make improvement, similar to what Ms. Jimenez stated. Hey, if he wants to show, you can pay, you can sit in jail. You want to put it all on the line with restricted visits and attend all those visits and start building your relationship from the ground up, then let's see it. If not, you'll take the easy way out. And judging from what he's done over the last, I'm sorry, I don't have the question in front of me, but X amount of years, odds are in your favor.
So Anna, call me. Evidently, what I need to say, we can't say publicly.
No, yeah. So seriously, this is, and it sounds like maybe she already had it or she has an attorney right now. So I will say this, and Anna, let's go ahead and let's stop sharing information. I'll have Keon send you that information. I'll post it here in a second about the firm. But you know, there are a lot of cases, like Floyd says, that we have to piecemeal the case together to get the end result. And it really, really gets frustrating for clients. It gets so expensive. But it can happen, right? I mean, sometimes you just got to take it one step at a time. And eventually we end up getting what we want. And I mean, I can't tell you the number of times that I've told my clients, we're going to make this happen. Like, we're going to figure this out. And it may take us a bit, but we do. And we get the kid, or we get to move, or we get whatever it is that we want. But there has to be some strategy put in place. And so I definitely, and if you have an attorney and maybe you don't know that what the attorney is doing is right, you can have a second consultation. And I'll tell you, a lot of times I'll tell clients they're doing everything that I would recommend. Like, I think it's just a bad fact pattern. And other times I'll say, yeah, they really screwed up on this thing, and this is maybe another way that we can pursue it and hopefully try to get you where you need to go. But I will tell you, just from what you've shared, you have a tough case. You have a really, really tough case, and you're going to need to make sure that you have some good attorneys on your side. So
yeah, I agree. Every time someone comes in and talks to me that has an attorney, I always tell them, like, look, I'm basing this solely off of what you told me. Your current attorney knows a lot more about your case than I do. And maybe he has strategic reasons for doing what he's doing, but based solely on what I know, this is what I think.
Right. And I mean, a lot of times when we get cases, you know, that we inherit cases from other attorneys, things have changed. And with that change comes a new potential strategy. So, I hate this, because I know overall what you're concerned about is your kiddos and their future and your family. And I know that this works a huge hardship on you guys. So I hate it for you. But, you know, the one thing that we always stress a lot when we're here in these, I got to come up with a name for what this is, for these Facebook Live events, is that the courts are always going to favor parents having a good relationship with their kids. And if you have a parent who wants to be involved, even if they haven't been involved for years and years and years, if they can come in and say, look, Judge, I've been screwing it up for the past 5 years, but I'm trying to make this thing right, and I don't want my kids to move, and I'm going to do whatever you tell me to do, and he doesn't, you're going to be stuck. And so that's just the way that it is. You know, and if you have a geographic restriction, you should have moved when he moved, right? You should have, and I know that that's easier to say now, and now you know, but barring that, you're stuck. So call us or call another attorney, and maybe we can figure out a way to get you what you're looking for, because I think ultimately that is probably, you know, you're thinking about your kiddos. So with that being said, though, guys, I think we have 4 minutes. Do we have time for another question? Or
well, before we wrap up, Devin's question kind of got lost in the shuffle. She was above Anna. she wants to know how she can submit a question. So it's kind of late now to submit it on Facebook Live, but as you can see, we try to pick them up off Facebook Live.
You
But-
can go into on our website, Devin, and there's a little contact us thing, and just put Facebook Live question, and then we'll make sure that we get it for next week. And we will make sure that you put your full name on there, please, because we were delayed a little bit with Anna because we always want to check for conflicts as we're talking about this stuff. And so submit your full name, and then if we are able to answer the question, we most certainly will. Cool tools? Okay, so let me pull up the disclaimer briefly. All right, so Floyd, do you want to do the outro since apparently I talk too much? Yeah, I want you to take lead on the outro since you were talking crap about my intro.
Okay, so this is officially the outro. It's going to be shorter than the intro because we only have a few minutes. But as we always say, Christina said it in the beginning a whole lot. You probably lost it in the long speech, but and then I don't know if we said it in the middle. Maybe we did.
I did, yeah.
Right, yes, but now we're at the end. We're going to say it again. Don't take anything we say as legal advice. This is just based on facts that are given to us and facts that Christina makes up as we go along. So we always recommend, if you have an issue like this, go hire an attorney in your area that knows what they're talking about, that has experience not only in the area but in the field that you're looking for and with the type of case that you have. With that said, anything else, fellas? Follow us on all the social media stuff: Twitter, Facebook, Instagram, TikTok, the whole. Did I miss these?
LinkedIn.
LinkedIn,
Tinder? Are we on Tinder? No.
Spotify.
Yeah.
Spotify. Oh my God, Floyd. Okay, with that being said, we are done. So have a good Friday, everyone.
Toodles.